Welcome to Sakshi TV special immigration show with attorney Ms. Prashanthi Reddy from the Law Offices of Prashanthi Reddy PLLC. Please note that Sakshi TV now has 3 immigration shows every week. On Wednesday at 5:30 p.m. EST with Ms. Prashanthi in English, on Thursday at 5:30 p.m. EST with attorney Chand Parvatnini, and on Friday at 6 p.m. EST with attorney Bhanu Milindra. Please tune in to ask your questions. And if you're an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call 866-725-7441. Before we begin the show, please note that the information provided on this show is not for legal advice and is for general informational purposes only. Sakshi TV or its agents will not be responsible for use of information. If you need specific legal advice, please contact the attorney directly. Ms. Reddy needs no introduction, but if you need consultation, please log on to reddyesq.com for contact information. And when you connect with them, don't forget to mention Sakshi TV. From the beginning, ReadyESQ.com has put a wealth of free information and online tools in the hands of immigrant community and for the benefit of US employers. The ReadyESQ.com site provides you with latest and cutting-edge information on US immigration law and policies, explained in terms you don't have to be a lawyer to understand. Today's topic is the H-1B RFEs and how to avoid them, and also immigration updates. We will continue the knowledge session along with the news and updates on latest immigration, followed by Q&A. But before we get into the topic, you can call us on the numbers displayed on the screen for questions related to immigration and also ask tips. Hi, Ms. Reddy, how are you doing?
Hi, Tony. I'm good, thanks. How are you?
Very well, thank you. You look really, really, really beautiful. You've really put, we're already very refreshed looking at you. So do you want to start the immigration updates first, Ms. Reddy?
Yes, let's do that. I have a few updates and then we can move on to the RFE topic.
Sure, Ms. Reddy. So what are the immigration updates? Is there good news?
Yes, there is actually. I mean, some of it is not good or bad and some of it is good. So, to start off with, USCIS is requesting separate checks for applications. So, for example, if you are an employer filing a H1, you might be used to giving one check for all the different fees. Now they're asking for, separate check for the basic 460 fee and then separate check for the 750 or 1500 fee. So there are different types of fees. Even for family-based cases, there are different types of fees. There's the biometrics fee and then there's the actual USCIS fee. So for all these types of cases where there are separate fees, USCIS is saying that they are transitioning. They've been transitioning for a while now to the electronic processing immigration benefit system, which requires them to use multiple systems to process the package, and therefore maybe they need to feed in the checks at different places or whatever it might be. So they're requesting for separate checks. ALA, Immigration Lawyers Association, its members have reported that they've been receiving some denials because of not submitting separate checks. And since it's on their website, I think we should adhere to this, and until further notice, we should provide separate checks to the USCIS just so that your cases don't get sent back. Another update, I just have some news on what happened with reference to last year's visas. So the Department of State gave out its 2022 visa report. So as per this report, non-immigrant visa approvals have spiked from 2.7 million in 2021 to over 6.8 million in 2022. Immigrant visa approvals also have increased from 285,000 to 493,000. Overall, so visa numbers in 2022 have gone back to pre-pandemic levels. So that is really good news for everyone concerned. So things going back to normal at the consulate is good. We still have delays for visitors visa, interview, application dates, etc. But we're hoping that will be resolved also with time. Also, immigrant visas, there's still a wait. It's better than it was, but there's still a long wait for immigrant visa application interviews. So, we're hoping that will be resolved as well. In addition to that, as a result of these delays with visa interview dates, last year the Department of State started something called a non-immigrant visa interview waiver process. And that, for those of you remember, the waivers were, so the Department of State basically said that all of those people who previously had a visa, the Department of State could then waive the interview, in-person interview, and they could then simply submit their documents in the Dropbox and get an approval. So that they've extended to this year as well, which is good news. December 31st, 2023 it's extended until. It was only until December 31st, 2022. So I guess they've realized that there's still a ways to go for them to catch up with their interview processes. So they are still waiving interviews. This I've heard in some instances is I heard mixed reviews of this because apparently when you do the Dropbox, you can't really submit all the documents that you want to. They don't take those documents. They just take the documents that they ask you to bring at the Dropbox facility, and then they're sending out administrative processing 221G refusals for not submitting all the documents. So I hear that some people, especially H1B applicants, visa applicants, are preferring to have in-person interviews rather than have the interview waived, because then going into administrative processing means a long delay. They're trying to avoid that. So that's just the flip side of it. There's always a flip side to everything. So that's with reference to our immigration updates.
Right. So thank you so much, Ms. Reddy. I mean, things are definitely looking up. If definitely it's gone, little of it has gone back to pre-pandemic level. But so as we get into the topic, Ms. Reddy, would you tell us what kind of RFEs to expect this season? Like, what kind of H1B RFEs do we expect?
So yes, for sure, and it's important to have this conversation because you will soon be filing for your H1s, and even now when you're filing for registrations, it's important to make sure that the person that you're registering for fully qualifies for the H1. And so there's some things that you need to look for to see whether they qualify or not, so that you can later on prepare a complete applications and avoid getting RFEs and then denials. So the first thing to look for is whether the job that you're offering the person is a specialty occupation or not. So the most common reason to get an RFE and then a denial is the failure to establish that the position qualifies as a specialty occupation, right? And there are many ways of doing this. So what is a specialty occupation? A specialty occupation is a position that requires a bachelor's degree in a specific field. And also the beneficiary should be qualified for that position. Also the duties should be related to that particular position, which you're saying is a specialty occupation. In addition to that, the duties have to be special enough, so complex enough to require a bachelor's degree. So that's another reason why they could send an RFE. If you put in duties that are vague, that don't really say what the person is doing, just 2 lines of duties. So so it's important to put in detailed duties and to actually bring out the complexity of the job and basically explain to them in your petitioner letter why that your particular job requires a bachelor's degree. Another way of proving that your job requires a bachelor's degree, which shows that it's a specialty occupation, is industry standard. So you can show that you have hired people with a bachelor's degree, say in computer science, if you're hiring a software engineer. You can say that you hired a person with a computer science degree in the past. You can submit their W-2s, their H1 approvals, you can submit their degree copies as proof that this is not a new requirement for you. Another way of showing it is to show that the industry at large requires a bachelor's degree in computer science for the position. Taking the same example of software engineer, you can refer to the Department of Labor website, which is the Occupational Outlook Handbook. Just Google it, and it has a list of occupations and the requirements, the educational requirements for most of the major occupations. So if it says in that particular handbook that a software engineer, most employers, doesn't have to say all employers, it's enough if it says most employers require a bachelor's degree in computer science, then that's one way to show that it's a specialty occupation, right? So these are the ways. And if you're not able to find any industry standards, you can also go to DICE or Monster or any of these recruitment websites, print out the requirements for a software engineer, the job openings, and show that most of them require at least a bachelor's degree in computer science, right? So that's one way of proving it's a specialty occupation, through the duties and through industry standards. So another RFE reason that USCIS will send RFEs is if you don't show availability of work. Now, if you do a registration for a person and you don't have work for that person, at least at the time of filing the H1, you have to show that you have work and what that work is. If it's a regular H1, which is not where the person is not working at a client side, say non-IT, a financial analyst or an attorney or an accountant or something of that nature, then all you need to do is show the give an explanation as to what is your requirement for this additional person. Maybe you can show a list of clients, you can show your tax returns, to show that you have enough volume of business to incorporate that additional employee. Now, if you're an IT consulting company, then it's a little different, because you show that by basically producing purchase orders, contracts from the client, letters from the vendors, from the end client, to show that you have a project for that particular person that you're seeking to hire. So those become important documents when you're filing the H1 in order to show availability of work. Now, if you are an IT company but the person is going to be working in-house, then again, the same way that you would show why a CPA firm would show why an accountant is needed, you have to show why you need that particular beneficiary. What is the project that they will be developing? What work will they actually be doing? What is the volume of your business? And your clients, say maybe your contracts, your project details, etc., etc. So there are many ways of showing that there is a requirement for that additional person. The reason they do this is they want to make sure that you're not hiring a person. And again, this stems again from the whole IT company scenario and consulting company setup. They want to make sure that you are not filing a H1 for speculative employment. So a lot of employers used to file H1s, get them on the payroll, and then look for a job for them. So they want to avoid that. So that's why they're, this whole thing of speculative in the concept.
Right.
So it's more important where, in the consulting company scenario more than, in other companies, in other businesses. In addition to that, beneficiaries' qualifications. That's another reason that USCIS can send out RFEs.
Right.
If you fail to establish that the beneficiary is qualified to perform the duties, for example, you have to show that the beneficiary holds at least a bachelor's degree in a specific field, or you have to show that the beneficiary has sufficient training and experience, and you have to submit a educational or work experience evaluation to show that he has the equivalent of a bachelor's degree in that particular field. So an evaluation becomes important. You don't submit an evaluation where it's needed, USCIS will send an RFE asking for an education or a work experience evaluation. Also, say the person has a bachelor's degree in chemical engineering, but you're actually filing a petition for him in information technology. So there's no relationship between a chemical engineer degree and what the job that he'll be doing. So you have to show the relationship. What is the relationship? What courses will he use to perform his work? You have to do course mapping, basically the courses, list of courses, and then the job duties. Which of the job duties correlate to which of the courses? So you'd have to do a detailed course mapping in that scenario. If you're not able to, based on the mark sheet itself, then you would show that, say, maybe he has 10 years of experience, a chemical engineering degree plus 10 years of experience, and you would get a work experience evaluation done for them. And usually the way evaluation companies do it, they evaluate 3 years of work experience to be equivalent to 1 year of college. So say they have an engineering degree and they add the 1 year of college, via 3 years of work experience, then they can give an equivalent of a bachelor's degree in information systems. Because even in IT, there are a lot of courses that are basic engineering courses, and then they take a certain number of courses to specialize. So, they can easily do that, the evaluation company. So all is not lost simply because they don't have a degree that's directly related. So that's another reason you could get an RFE. And the fourth reason you could get an RFE is, of course, maintenance of status. USCIS usually issues RFEs to petitioners that fail to establish that the H1 beneficiary properly maintained his or her status. So to resolve this, the beneficiary has to submit copies of their I-94, their approval, their pay stubs, employment verification letters, etc., etc. If they're already on a H1, if you're filing a change of status, say during the CAP, from a H4 to a H1, then you have to show that the H4 spouse was in status. So you have to show their pay stubs, their approval, then the spouse's H4 approval, and show that the I-94 is not yet expired, and the marriage certificate to show based on which they got the H4. You have to show the dependent status. Similarly, if you're filing a change of status from an F1 to a H1, there are a lot of maintenance of status questions that can arise, and usually these are the most common RFEs we get during CAP season, because we do a lot of F1 to H1 change of status applications. Usually in this instance, they will ask for the proof of status of the student. If they're on OPT or CPT, did they maintain their OPT or CPT status? How did they maintain it? Say there are certain preconditions for an OPT. You should have worked for a certain period of time, even if it was voluntarily. So they'll ask for a letter from the employer where they worked. If you're on CPT, then again you have certain preconditions. You cannot, if you have worked on the day one, as soon as you enrolled in school, you take CPT and start working immediately. There'll be day one CPT RFEs where they ask for why the organization or the college requires you to take CPT on the day one or work on day one of your college. So they have to show that the course is such that practical training and theory are combined, and one cannot be done without the other, right? So they have to show that that's how their course is. It's heavily dependent on practical knowledge as well. So these are some issues that come up with F1s and maintenance of status. Also, a lot of people studying remotely because of COVID. We had again a lot of RFEs because they wanted to make sure.
I'm sorry to break you, but as long as we're on the subject, you said, are there probably particular fields of study that this might apply to? As in practical and theory going hand in hand might be more applicable to any kind of field of study or work that needs a practicality. What about managerial studies or anything related to creative arts? Would that be the same? Would that differ depending on the course of study?
No, it wouldn't. You just have to show that practical application is part of the course, and that you have to show how the course is designed. So it doesn't have to be just IT related. As you said, it could be a more, a bachelor's in fine arts where you require to I don't know, work in a studio or something, or a bachelor's in hotel management, where you're required to show some, do some practical work on the side,
Right.
along with your coursework, and you get credits for that work. That's what CPT is about. You actually get credits for the work that you do outside. So it's part of your course. So it really
Right.
doesn't matter, to your question, it doesn't matter what kind of course it is, as long as they show the relationship between the CPT and the course.
Right.
Right? So they always ask for a letter. They ask for that, in fact. So we usually submit a letter mapping out the person's job duties at that CPT employer and the coursework that they're taking and how they're related. So this is often a question that they ask, and we have to map that out and send them, a response in the form of a memo. So how do you avoid that? I mean, you can submit all this documentation ahead of time. In order to avoid these F1
Yeah.
CPT and OPT RFEs are very common. So, something to think about.
Right. Right.
In addition to that, you have to show that the LCA that you're submitting, LCA is one of the forms, it's the form that's approved by the Labor Department before you actually file the H1. So you have to show that the LCA corresponds with the I-129 or the H1 petition that you're filing. Say, for example, the job title has to be the same on the LCA. The wage has to be the same. The work location has to be the same. So you can't have different information. It all has to be the same. If there is a difference in information, then your case will most probably get denied, unless you make a mistake on the I-129. That can be changed, but the LCA cannot be changed, because once it's approved, it's approved. You cannot amend an LCA. So you'll have to refile the LCA and then refile the H1B petition, because one of the rules is that LCA has to be approved before the filing of the petition. So you can't file a new LCA after you get an RFE. So always make sure that the LCA that you give, the information that you give on the LCA is, always correct. Another reason that you get an RFE could be that you are close to maxing out on your 6 years on a H1, or you've already maxed out. So then you have to say on what basis you're filing this H1 beyond 6 years. So this, I think it's important to do it beforehand itself, in your cover letter, in your attorney cover letter, or in the petitioner cover letter. Put in the information, like if you're qualified based on I-140 approval, because as per AC21 regulation, if you have an I-140 approved, you can file a H1 beyond the 6-year limit. So you have to put in the I-140 application and write it in the cover letter that they're filing based on the AC21 approved I-140 petition, right? So this, if you don't put it ahead of time when you're filing itself, and if you don't look at all this information when you're filing your petition, then you'll get an RFE, and RFEs, once you get an RFE, then the chance of a denial becomes much, much higher.
Right. Right. So, Ms. Reddy, before we, conclude the show, I wanted to really ask if there's any one kind of H1B RFE situation that you recently probably dealt in your own office. Some real scenario that, any RFE that you looked at, something more common, where probably you didn't expect, this issue to probably blow up. It could have been avoided by a silly correction, maybe something like that.
Actually, a lot of these, what I'm talking about, we've dealt with all these RFEs.
Right.
They're so common, so we know what to avoid, and we try to put in an application whereby we don't get an RFE. But sometimes, either because the client doesn't listen to us and doesn't want to submit so much information in detail ahead of time, or because of some oversight, it's also possible that we do get RFEs. Sometimes they're completely surprising. We don't expect that there's an RFE, and sometimes they're not. So, for example, recently we got an RFE for a software engineer to prove that it's a specialty occupation. Now, this is not something we do in advance, proving that a software engineer is a specialty occupation, because this is one of the most commonly filed job positions I must say ever.
Right.
So we didn't expect we'll get an RFE, but then once you get it, you can't take it lightly. So we had to go through the entire 9 yards. We submitted, we got an evaluation done, an expert opinion evaluation from a professor, gave him the job description and asked him to evaluate whether, based on the job description and the qualifications of the beneficiary, he thought that the job required a bachelor's degree or not. Then we got whole bunch of printouts from Dice, Monster, Indeed, LinkedIn, to show that, a software engineer position, generally they require a bachelor's in a specific field in computer science, not just a bachelor's in engineering.
Right.
Then we submitted all the W-2s of all the employees that worked as a software engineer before. And we created a list of all the employees that were working before and presently working, and their job titles and their degree copies. So we created this whole list. We didn't take it for granted and just tell them. We could have just said, hey, look, you've approved 10,000 other cases as a software engineer. So, you can't send us this RFE now. Then they would have denied it. So don't take
we're not
anything.
different. Right.
Don't take anything for granted. Don't be smart with USCIS. Just respond to. You can be smart. You can say whatever you want, but respond to what they're asking for. You can put it
Right.
within there, and we did that. Look, this is the most common type of H1 that's being filed. So we're surprised that the officer is sending an RFE asking for blah blah blah. We put in all that language so that it'll help them in their training. But we did respond with all the information. It was like 30 or 40 pages of information. So I was definitely surprised to get an RFE for something that's so commonly filed. So it just goes to say that, USCIS is unpredictable.
Right.
Sometimes then we had another H1 also, and I think we're running out of time, and we can talk about it later. But yeah, there are a lot of case scenarios we can discuss.
Right. So I think we'll definitely look at the case scenarios that you have dealt with personally in your office with your expertise in the coming show. And with that, it's always a privilege to host you, Ms. Reddy. Thank you for being on our show.
Thank you, Tony. Take care. Bye.
You're watching Sakshi TV Live. This is Torini. Thank you.